So reading 3.1 talks about the strategic behavior of judges and how judges have strategically engaged in certain actions in order to build up the institutions in which they reside. This is a common theory to explain judicial behavior, and I want to juxtapose it with the other theory that is used to explain judicial behavior, primarily in the field of law and courts, and that is sincere behavior. So we tend to think of these two things as sitting on opposite sides of a spectrum. Sincere behavior is perhaps the easiest to understand. Sincere behavior says that judges engage in judicial behavior as a consequence of their sincerely held beliefs. In terms of decision making, this is perhaps easiest to understand. What sincere behavior in judicial decision making says is that judges simply vote their ideology, that irregardless of any other sort of conditioning, judges vote the way in which they truly ideologically feel. Said more simply, Justice Clarence Thomas votes the way he does because Justice Clarence Thomas is conservative. And Justice Ruth Bader Ginsburg votes the way she does because Ruth Bader Ginsburg is liberal. Now, this theory of explanation, this sincere behavior explanation, operates in the field of law and courts under the theoretical moniker of the attitudinal model, simply meaning that judges vote their attitudes. Now, the attitudinal model works fairly well on the United States Supreme Court because of a number of institutional rules that those judges reside in. First and foremost, the United States Supreme Court justices have life tenure, which means that outside of extreme behavior, these judges cannot be removed from office. Second, they can't be directly punished. Their salaries cannot be reduced while in office, and this sort of gives them a degree of freedom. The third part is probably the most important part for sincere behavior for the attitudinal model, and that is their decisions are not immediately overturnable, that their decisions are binding law and binding precedent on all of the lower courts. So sincere behavior, the attitudinal model, works very, very well on the United States Supreme Court. When you get to lower courts, it tends to work less well. And it tends to work less well because of the institutional arrangement that exists and because their judges may have other goals. So we assume that at the United States Supreme Court, judges have one primary goal, and that is to see their ideology written into law. When you go lower down in the judiciary, when you go lower into the federal judiciary, and even within state courts, we tend to recognize that judges may have other goals. They may have alternative goals. And when we start talking about this goal orientation, we're really bringing in the idea of rational choice, that judges will attempt to accomplish their goal in the most efficient means necessary, by the most efficient means possible. This opens the door to things that theory we like to call strategic behavior, and that's what the reading in Article 3.1 discusses. Strategic behavior assumes that judges have a number of goals, and among those goals, they can rank order the goals that they wish to see. By rank ordering these goals, judges may forego one of their goals in order to pursue another goal. So in terms of judicial decision making, allow me to give you an example. Let's say and this is very akin to Congress, and this will make sense if you think of it in terms of Congress. Let's say on one particular case, a judge has really no care about the outcome one way or another, but he or she is very passionate about the outcome in the next case that they're considering. That justice may agree to vote in whichever way other members of the court wish her to, if they will vote with her on the next case. That's engaging in strategic behavior. That's trading a vote in one circumstance to gain other votes in another. What other sort of mechanisms does strategic behavior do very well in terms of explaining? It explains very well sort of the behavioral orientation of state Supreme Court judges. So we know that state Supreme Court justices are concerned with their retention. They're also concerned with seeing their ideology written into law. But there are some necessary prerequisites there. Judges can only maintain their position if they are retained on state Supreme Courts. So let's take a look at elected judges. Let's take a look at Texas, for example. Let's say in any given case, the judges wish to do something that is unpopular. So let's say in Texas example, that would be striking down an abortion restriction passed by the state legislature and signed by the governor. Let's say that legally, that's the right outcome, is they should strike it down because it offends either the Texas Constitution or the federal Constitution. But these judges know that abortion restrictions most likely are fairly popular in the state of Texas. So if they wish to stay in power, they can't make the ideological decision that they want. So they will then, in those cases, show deference to the electorate and make the decision that the electorate wants. That's engaging in strategic behavior. That's prioritizing one goal over another. And in this case, the long-term goal that they have, that is staying in office, is a prerequisite and a necessary condition for them to continue making decisions that align closely with their ideology. A sincere behavior explanation would be that judges will simply vote the way that they wish to ideologically without recognizing any other goals that judges would have. State Supreme Courts, because of the variation of the institutional mechanisms that exist, and because these justices don't have life tenure, are much more likely to engage in strategic behavior as opposed to sincere behavior. Let me give you another example. Justices on the United States Supreme Court in terms of retirement. The general knowledge that you hear, and it's not at all accurate, is that justices will be more likely to retire when the president can appoint someone who is ideologically similar to them. So the reason why Ruth Bader Ginsburg is holding on through the Donald Trump presidency is because she hopes that a Democrat gets elected and she can retire under a Democrat and a Democrat can replace her. She may actually be trying to do that, but she absolutely could have done that under President Obama, and she didn't. So what we find is that oftentimes this sort of strategic behavior, at least in terms of retirement, doesn't happen at the United States Supreme Court. And for a number of circumstances. One, individuals there simply wish to remain in power over time, and retirement is leaving power. And so they don't tend to retire strategically. In fact, the studies that I've seen is that individuals who if they are trying to do that, they actually fail and they end up dying in office as opposed to retiring. For example, when Justice Anthony Scalia passed away and gave a Republican president his nomination, that wasn't, or gave a Democratic president his nomination, that wasn't strategic behavior. He died. That's not strategic. Let me re-say that again. When Justice Antonin Scalia died, it wasn't a strategic sort of thing because he could not give his nomination to a Republican or a Democratic president. So there's no way that it would play out. And what we've seen is that justices who maybe do try to engage in this strategic game ultimately fail. And at least on average, across the entire timeline of the United States Supreme Court, it just doesn't play out that well. But looking at state Supreme Courts, it absolutely does. First and foremost, it's much easier because of terms to motivate judges to retire. So Justice Ruth Bader Ginsburg doesn't have to retire ever because her term is never up. She's never actually in a position where she could step down. But judges who are appointed, at least at the state level, are much more likely to retire when the body that's in charge of reappointing them is ideologically congruent with them. And that's because probably because terms sort of set a standard. And if you can step down at the end of your term, that term is sort of motivates your retirement. Plus another thing that states also have is states have mandatory retirement ages. Most states have a mandatory retirement age somewhere between age 70 and age 75. And those institutions tend to motivate judges to retire strategically. Another example of judges retiring strategically is judges whom are elected. Judges whom are elected, if their previous election was close, let's say they won 51% to 49, that means that they're weak. And in that circumstance, they're almost as likely to retire in the next election cycle as they are to run again. And that retirement is strategic. They don't want to be labeled a loser because if they want a further political career, that labeling of a loser is bad for them. So in terms of judicial behavior, we tend to think of these two primary ways in which we can explain almost all types of judicial behavior, and that juxtaposes sincere behavior, that means behavior that is taken out because of the attitude and ideology of the judges, versus strategic behavior, which is the balancing of numerous goals and attempting to actively get them while perhaps sacrificing other goals in the process.